Hi, this is Elizabeth Floyd providing a lecture on juvenile justice, which is lesson module 8 for our course this semester. Here are the objectives that I have for this lesson module. And I'm going to start out, and I'm not going to go in exactly the same order as your textbook does. I've got things a little bit reordered here. I want to start out by looking and really just answering the question, why do we have a different system for juveniles than with adults? And a lot of what we cover is about that, answering that very question, why do we have this separate system? And it really starts out with statistics. There was an observation made by really smart people that um, juveniles are disproportionately represented in the number of offenses committed, not just in the United States, but worldwide. So this isn't just a US thing. This was something that all countries were noticing. Why was it that most property offenses were being committed by teenagers, essentially, or a disproportionate number of teenagers were committing, and it was usually property crimes, not necessarily violent crimes. But it was an observation that seemed to exist universally across all, at least Western European cultures. And so that suggested that, well, there must be something unique to juveniles, to teenagers, for this to be true. Because after those teenage years, in the early 20s, the crime rates tended to drop off. And so, what's happening then during this time period in a person's life that would make them more likely to commit crimes? So, we start out when you ask that question, why do juveniles have their own justice system? Because there was an observation that something unique is happening to juveniles, and not just juveniles in America, but juveniles in all countries, that is making them more likely to commit usually just property offenses. And so neuroscientists wanted to give this a look to see what's happening to the juvenile brain that's leading to this observation, this statistical trend here. Um, and so what they've learned is that the human brain structurally does not reach maturity until you're in your early 20s. You guys may already know that. But pretty much everything else in your body is physically mature, like your height, your weight, your muscle mass. They'll change a little bit, but by the time you're, in your high school age, you're about the size physically that you're gonna be. What's still changing is your brain. So your hormones are whacked out and your brain isn't structurally, um, fixed. It's not reached maturity yet, but the rest of you is. And so there's this incongruity between the maturity of your brain and the maturity of the rest of your body. And you can couple that with the environment. Um, some, juveniles that are born into tougher neighborhoods, maybe there's only one parent who can be at home with the child. Um, and then there are personality factors that come into play that makes a child want to rebel or to fight back, a pushback against parental control. And so you've got nature versus nurture working together. During puberty, during your teenage years, your hormones are going nuts because your brain is still changing. And then you're also kind of at this point in life where you are pushing back against having your parents make all your choices for you. You feel ready to make your own choices. So you push against them and you rebel. And then your environment, if you live in a neighborhood where you're exposed to opportunities to commit crimes, you're more likely to get involved in those crimes. And if there's less supervision at your home or in your community, by adults, then it's easier to get mixed up and make mistakes. And so it was those observations that have taught us that juveniles are different than adults. Their brains are different. Their I guess you would say their lives are different. Just where they are in their lives are very different and changing. You know, there's rapid changes that happen in a teenager's life, both just in school and the choices for their future, as well as in the growth and development of their brain. So it made sense that we should have something adapted to that juvenile experience. So that's one reason we have that may justify having a different system for juveniles. Now we'll take a closer look at what we mean by juvenile offenses, because there are some offenses that are unique to a juvenile. So these are called status offenses. This is behavior that is illegal only because it's being committed by a kid. It would not be illegal for an adult to do these things. An example is like underage drinking, underage smoking, skipping school. Those are things that would not be illegal were it not for a person's age. Um, and then there are true offenses where it's a crime regardless of how old you are. And those are defined as delinquency, delinquent offenses. And those are the things that are more likely to get you into trouble with the law. You know, if you're truant or you're engaging underage drinking, those status offenses are probably going to be handled by family. But when you start committing crimes as a juvenile, the justice system is more likely to get involved because those are crimes that are crimes no matter what age you are. And so when we're looking at juvenile offenses, you got to split those. You got to look at, okay, what is the offense? Is it a status offense or is it delinquency? Because they're treated differently by the justice system. Okay, still sort of answering the question, why do we have two different systems? And there are other historical factors that have kind of contributed to the different systems that we have in place now. And one of those is um, the the way we look at childhood. Like what does our culture think about children and the childhood years? How do we see it? How do we perceive it? So that's why I've got up here, cultural perception of childhood. That has changed a lot but we're talking about a really long period of time. Um, Another thing that has affected the way we treat juveniles is, and these two really go together, immigration and poverty. Because as I go through the history, you're going to see that with the Industrial Revolution came massive influx of immigrants from Europe to come and fill the jobs of the industries, the manufacturing plants that were being built in the United States of America. So most of the laborers in those plants and industries were immigrants, poor, desperate immigrants. And so there was this kind of influx of a huge population increase, and there weren't homes available that they could afford to live in. So they were moving into, concentrated in these apartment complexes um, that were not the best places to live. You know, they're run down, not well kept up by the landlord. And so it's kind of there, you might call them tenement homes. I know that's probably the word that's used in another, like in England, but I'm not sure we use that word in America to refer to it. But poor neighborhoods develop near these industries and plants where immigrants were going to work, and they could not afford to keep it up. And so you wind up having a lot of children who are running around in the streets. They don't have a safe place to live. They're probably not going to school. They are desperate for food because they're hungry. Their parents are not being paid well, working at the plants because there's, historic discrimination against immigrants. And a lot of times the children were working in these plants as well until child labor laws came into play. So you couple that immigration and poverty in with our perception of childhood, and you'll start to see the relationship, but of those things, the relationship of those things with the development of our juvenile justice system. Okay, so here's the timeline. I'm telling you, we're covering thousands of years by this timeline. You can start with the most ancient times, where the government had no involvement at all in the rearing of children. It was entirely up to the parents. And we're talking about a paternalistic society. So that means it was up to the dad. The father had total control over what happened to his or her children. And that means he's accountable for any crimes they committed, but he would handle their punishment. And there were no laws that would protect children from abuse by their parents. It was whatever the father said went. That's just the way it was. Children were often even seen like property, the property of their father. Anyway, it was a tough time, you can imagine. But it changed. Okay, so the more civilized we get, we start understanding that there is love between parent and child, and there's more time for those expressions of love as technology develops and allows more recreation time, more appreciation of non-work time. And so in that sort of progression, you start seeing very modest limits on the authority of a father. So this is a very gradual thing, but over time, government started to kind of move in and offer a little bit more protection of children, even from their own parents. Not a lot. Okay. Just minor little changes began to occur. And by the time you get to the Middle Ages, you start to see a full-fledged recognition that sometimes government has to get involved for the best interest of the child. And that's what parens patriae, that Latin phrase you see there next to Middle Ages, that's what that means, that the government can stand in the place of the parent when it is necessary for the best interest of the child. And that really started becoming commonplace during the Middle Ages. And it had something to do with the influence of the Christian church in society. The Roman Catholic Church had a great deal of power, political power at this time. And within that church was an understanding of spiritual responsibility. So before a child reached the age of 7, the child, as far as the church was concerned, had no spiritual accountability. We were not worried about children sinning or a need for them to repent. But once they get to be about 7, and until they're about 14, they begin to be taught about sin and repentance and penance, things they had to do to make up for their sins. So that spiritual accountability is gradually introduced once the child gets older than 7 or right around age 7. And then once they're 14 years old, well, the church considered them adults and they were fully accountable for their sins and had to follow the same rules that adults did as far as making up for the sins they committed. Well, because the church had so much control over politics, that rubric of sorts was kind of moved into the secular world of accountability for crime and criminal offenses. And so that's where you kind of start seeing government getting involved when children reach a certain age. Then the government, or at this point would be the king, would kind of get involved and step in, around a certain age. So let's look at that a little bit more specifically. And how did the state or the king begin to intervene with juvenile discipline? And what they would do is remove the child from the home. That was, or one of the things that they did. Originally it was called binding out. they would take the child away from the parents and place them with foster parents. It was often so that the child could learn a trade. That belief being, well, if the child had something to do and could use their hands to work, then they would be less likely to get in trouble. And so the court would see, parents who are poor and they can't take care of their children very well. Well, we'll take the children away and put them in a home where they can learn a trade and they won't be committing crimes. That was one way that the king would get involved. You also would see in this time period new laws that made begging and vagrancy illegal. And this is where you're seeing a connection to poverty. If you don't have food, if you don't have a home, you have no choice but to beg and live on the streets. And then laws are being passed that make it a crime to beg and live on the streets. So the children who were among the hungry poor were going to be arrested for a violation of these crimes. So what do we do with them? Well, you could stick them in prison with adults, which did happen quite often. But it was possible now that we have parens patriae playing a role that the king would place the child in foster care so that they could be essentially an apprentice to a tradesman. This time period, again, this is a progression, not, marked adjustments. All of these changes are very gradual. But moving up through history, we get to about the 1500s, and this is when a new model takes over. It's called the congregate institutional model. So congregate, think group, institution, building. Okay, so that's the idea now. From about the 1500s on, instead of putting children in individual families, we're going to put them in an institution, in a building. And that kind of, you start seeing that happening in the 1500s. They originally called, well, generically, they're called workhouses. But one of the first workhouses, I think, may have been owned by someone named Bridewell. I'm not sure where that name came from, but that's what they were called, Bridewells, workhouses. And they were just places where children would be gathered up and sent, and they would live in these institutions and they would work. It was intended to teach them what's known as habits of industry, a work ethic, in other words. So they would be expected to do really tedious, boring, probably not safe work to teach them this work ethic and hopefully correct their behavior. But it's essentially exploitation of children when it comes down to it. Some of the time, the children were sent to the colonies. And so we're talking about Western Europe, England. Children could be sent as indentured servants over to America or to other places where England had colonies. But the American colonies inherit their legal philosophies from England and Western Europe. So the American version of the Bridewell was known as the House of Refuge. The first one was in New York, and that's what I got a picture of here on the screen. They're essentially the same thing. They were places where the poor, the juvenile delinquents, were sent so that they would not be living on the streets. So homeless poor, often immigrants who had come over to work in the industries that were growing up in the urban centers of the colonies or now states. We're talking about the mid 1800s now. The poor immigrants, to get them off the street so that the, fancy white people didn't have to deal with it, they would be sent to these places called houses of refuge. And doesn't that sound nice? A house of refuge, like it's peaceful and supportive. Not necessarily so. They were required to work very hard and probably were not treated very well in these homes. I'm not saying all of them. Some of them may have really been successful and accomplished good things for poor children, especially orphans who really had no one to care for them. But in other situations, there was exploitation. An alternative to a house of refuge was a reform or industrial school, which is more structured, and there were efforts to educate children in these schools. So they're learning to read and write, do math, basic academic skills, and are being taught various trades so that when they reach adulthood, they can go and get a job. So that's just a slight modification of the House of Refuge. We're industrial schools. Um, in the 1830s, there was a U.S. Supreme Court decision called Ex parte Kraus. And this is really the first time you see the philosophy of parens patriae become part of American law. Parens patriae is actually a principle of equity that was applied going back to the 1500s, like I said, in Western Europe. With the development of the Chancery and Equity Courts came the philosophy of parens patriae that was applied so that children weren't treated as adults, but rather were treated in equity as wards of the state and who could be bound out or apprenticed in some way. Well, in the US, we're our own country now. We have our own court system now. And those principles of equity are kind of blending in with the legal principles that our courts apply. And here in this case, we draw in that equitable principle of parens patriae, that philosophy that a court can intervene when necessary, stand in the place of a parent when necessary for the best interest of the child. That was the first time we saw that happen in a reported decision. When we get to the early 1900s, and I'll remind you, I promise last time I'm going to remind you, this is a gradual process. There's no marked event or shift, sudden, nothing sudden about this. It's a gradual process. So gradually over time through the 1800s, American courts now have a precedent for parens patriae, and they are gradually getting more involved in the handling of juvenile delinquency and dealing with juvenile offenders. Oftentimes, depending on their age, remember that age rubric 0 to 7, 7 to 14, 14 and up, that's at play in America. We inherited that from England. So those were the rules of law that were governing the extent to which a child be treated as a child versus a child being treated as an adult in the American court system. But when we get to the early 1900s, late 1800s, with the progressive movement, we see a new effort to make the treatment of juveniles more fair and sensitive to their age. This group of women known as the Child Savers, they successfully advocated for rather than putting children in prisons or putting them in these houses of refuge, well, we'll send them out west. Okay, so think manifest destiny, moving out west. A lot of people are conquering the Western territories. And the idea is, well, we'll take these poor orphans, get them off the street, and we'll send them out west to live with a farm family where they can learn how to become a subsistence farmer and develop a work ethic, probably get some sort of education. It really isn't. It's a desire to do what's best for a child. When the parents can't provide, the government steps in the place of the parents and provides them with what was intended to be a safe home where they could learn and grow and thrive. I'm sure there was exploitation of children that happened at times. I don't know to what extent. I'm trying not to be pessimistic about it. Okay, so it's through this process, this sort of trial and error, gradual development of precedent where courts are intervening and doing what's best for the child when parents can't, that we start seeing the first separate juvenile justice systems in urban centers where you've got courts having to deal and having such a high caseload of juvenile cases. They start to realize, well, if we've got to treat juveniles differently. Our regular justice system just isn't equipped to do that. So let's get some tax money here and invest in an entirely separate system of justice for juveniles, where we can apply parens patriae and we can use equity to deal with the child based on a very individualized approach. Why is the child committing the offense? What is the offense? What's the child's home like? Has the child been given an education? So they would apply this very individualized approach to the situation. It would be something very different than an American criminal proceeding. The judge would have a lot of discretion in what happened to the child and in what evidence he considered or didn't consider. Now, this huge amount of discretion is being granted to the judge, but there's really no limit on his choices, the judge's choices for the child, so that it's not necessarily fair. It sounds good. Okay, we're giving a child an individualized treatment, but there's no structure for it. And there's no consequence if the judge does something that's unfair. There's very few protections. The judge could come up with a sentence of sorts that is entirely disproportionate to the offense, and there's no way to stop them, no way to change it, no appeal. So it has its upsides and its downsides, but there's enough of a problem there, enough bad, that we have the introduction of due process, that now it's going to kind of gradually make its way into the new juvenile justice system. And there I've got it. You see, unbridled discretion of judges, and who at times will punish a juvenile offense unfairly, and there being no recourse for the child. That unfairness drives change, drives reform. And so around the 1940s and forward, the U.S. Supreme Court starts to find that it is only just to provide some due process protections in juvenile adjudicatory proceedings. So in your textbook, there is a long section of it with a bunch of different U.S. Supreme Court cases, and you'll see this kind of gradual introduction of due process into the justice system. And I'm going to kind of narrow down a little bit the ones you really ought to pay attention to. And we'll start with In re Galt, because that's kind of the big case that really first recognizes specific due process rights for the child. And I hope you'll read about that case. It's pretty shocking. You got to put yourself in the place of this kid. I think he's 15. He may be a little bit younger than that. I don't remember, but he crank calls somebody, a lady, I think an old lady, poor old lady. And he makes very sexually inappropriate comments to her. She's offended. She calls the cops on him. They show up. Mom and dad are not there. So they take the kid before the court. They don't even leave a note. So mom and dad don't know where their son is. And the judge sentences the kid to 6 years in prison for crank calling a sweet old lady. And it's wrong. What he did was wrong and should be punished in some way. But if an adult had done the same thing, they would have gotten a slap on the wrist. But here we have a judge with unbridled discretion in dealing with juvenile delinquency, sentencing a kid who had no due process protections, parents weren't even there, sentencing them to 6 years in prison. It's ridiculous. And that's, the straw that breaks the camel's back as far as the Supreme Court is concerned. And they recognize 5 due process rights that must be afforded to juveniles in adjudicatory hearings that may result in a deprivation of liberty, so a jail sentence. The child must be given notice of the charges against them, has a right to an attorney, can present his or her own witnesses and evidence, and has the privilege against self-incrimination, and may appeal the decision. So those are really important basic due process rights are going to be afforded to even to juveniles, even in this separate system. And then there are several cases that come, that follow the In re Gault, and the result is kind of a long list here. I've got it on the slide. These are the rights that are granted to juveniles, the due process rights. Most of them are, not all, but most of them are afforded to juvenile offenders. There are two, so it's easier to remember which ones are not granted to juveniles, and that is juveniles are not granted an absolute right to a jury trial. Jury trials can be public, and if we want to protect a juvenile and expunge their record when they reach 18, give them some privacy and anonymity, you can't have a public jury trial. So it's not a guarantee that the Supreme Court will recognize for juveniles. The same thing is bail. If a juvenile comes before a court, the court still has the power to put them in a detention center and not give them the right to bail and release, because oftentimes there isn't anywhere for that juvenile to go. He may be homeless, or maybe his home life is not safe. So courts still have some discretion about whether they're going to release a juvenile to his family or hold the juvenile. So that right to bail that adults are given are not necessarily going to be given to a juvenile depending upon the circumstances. So in the end, the doctrine of parens patriae has not gone away. We still have a lot of judicial discretion in the juvenile system, but to prevent that discretion from being totally without structure or limit, there are a lot of due process protections that are currently afforded to juveniles in these adjudicatory proceedings. And one I didn't specifically mention had to do with sentencing, but I'm not going to go into depth on lecturing about it because the textbook does a great job of kind of chronicling all these key decisions, particularly the cases of Graham and Miller and Roper. And you can kind of see that the death penalty and life sentences are dealt with very differently for juveniles than they are for adults. So read about that and you'll get it. But now let's talk about the actual process. So we've got, I think, an understanding of why juveniles are treated differently. So how are they treated differently? They do have some due process protections, not all of them. And what typically happens is when a juvenile offender is brought before a judge, the judge has a decision to make. Is the judge going to treat this juvenile as an adult, or are they going to send them to the juvenile justice system? So that's decision one, and that's called waiver. And waiver varies a great deal state to state. And what I have on this graphic on the screen, that's the waiver process for the the South Carolina juvenile justice system, or the state of South Carolina. The way it works, in some cases there's a statutory mandate, for these types of crimes committed by offender of this age, you must prosecute them as an adult, or you cannot prosecute them as adult. All right, so statutes can be written to dictate waiver or not waiver. But then added to that, some discretion is given to prosecutors and to judges. So there's this wiggle room kind of in the middle where, depending upon the age of the offender and the offense, the prosecutor or the judge can decide, are we going to waive them into the adult system, or are we going to keep them in the juvenile system? How are they going to handle it? And so the graphic is kind of meant to show you like the flow chart of what happens. So they start out in the DJJ, and the judge there decides, are we going to prosecute this offender, or are we going to dismiss them, send them to some sort of diversion program that the community provides? All right, if we decide we're going to prosecute them, we're going to send them into the family court system, or are we going to send them to the adult system? So it moves on. There's an evaluation of the juvenile and of the case to decide whether they'll be prosecuted as an adult or as a juvenile, and then the system moves on from there. But this is a state to state sort of variation, the waiver process. And what I've just described for you is the way South Carolina does it. Not all states do it that way. But they're probably pretty similar. I just don't know much about what other states do. The newest trend in juvenile justice is something called restorative justice. And I want you to pay close attention to this because it's what you may see, very likely to see if you go into juvenile justice for your career. And South Carolina does use this method in their diversion programs that I was talking about from this slide. You see dismiss or divert there in the bottom left of the graphic. Divert means to send them to some sort of alternative treatment that doesn't involve a detention center necessarily. There are a lot of diversion programs that are available, but they all have some things in common, and that's what this is meant to show you. Restorative justice is it's the new philosophy of how we're going to deal with juvenile offenses, and it has certain priorities that are different than the adult system. It's focused on the offender and the victim and the community. So the philosophy is we've got to take all three people or groups, their communities, not one person, into account when we try to resolve an offense committed by a juvenile. So they're going to look at what was at the offender, what were the circumstances that that person is living in, what's his family life, education, history, that sort of thing is taken into consideration. What are the needs of the victim? What is the desires, hopes? What does the victim want to have happen to the offender? So the victim is included in the sentence that is applied. And the community, the safety of the community is also considered. And so these three things kind of work together to come up with you say sentence, but don't think of jail sentence. And don't think of punishment, because although punishment and accountability you see are part of it, it's not all there is. So it's more than an adult's, like a verdict and then the judge gives a sentence. It's more collaborative, and the hope is the victim will receive closure. The victim's voice is heard. What the victim wants to have come from this proceeding will come. They have some say in the outcome. The court is going to look at the community and look at the resources the community can provide to help the offender learn from his or her mistake and somehow make up for it. So is there a way, some sort of service that the offender can provide to the community? They'll teach them a lesson, but also teach them pro-social behavior. There are often mediations that occur where the offender and the victim come together and talk about what happened. The offender learns of the impact his bad choice had on the victim, and that helps them understand the consequences of their choices and how it affects those around them. Those are really good lessons for teenagers to learn. So this is a very well-intentioned program that has had a good bit of success throughout the U.S., and then we're seeing it in Western Europe often as well. So one of your projects, you actually have two projects for this module. One is to work on developing your own sort of timeline of the juvenile justice system in America. And then the other is to go online and learn more about specific restorative justice programs. And you can just use Google, whatever search engine you prefer, and then type in restorative justice programs. See what comes up. There's a lot of stuff I've found on YouTube, a lot of interesting stories of these programs. They tend to be used in urban centers that had high crime rates among juveniles, where there's a strong progressive fervor among the justice system employees to try to come up with new ways to deal with juvenile offenders. And you'll hear some really cool stories that, and they're often successful, of the programs being applied for juveniles. And so, what I want you to do is find one you find that you think is really interesting, learn about it, and then share it with the rest of the class through a discussion post. And I have some pretty detailed instructions in the learning module that you can follow along with in order to accomplish the project. That's all I have for the lecture. And if you have any questions about anything, please feel free to email me.